That's very normal. And someone speeding isn't alone an indicator of impairment, correct?
No.
Not everyone who's speeding is impaired.
No.
No. And someone not having their lights on alone is not an indicator of impairment, correct?
No.
Not everyone who fails to have their lights on at night is impaired.
Correct.
Right. Nothing further.
Officer, I want to start from the beginning of your investigation. When you first encountered the defendant, can you tell us what his vehicle was traveling like?
It was at a high rate of speed and with no headlights on.
I know that defense counsel just asked you about if these things taken alone could be construed as impairment. When you're looking to see whether somebody is impaired, are you just basing your decision on one thing alone at a time?
Objection. Bolstering, and also are you invading the province of the jury? Whether or not she believes Mr. Riley was impaired does not matter. It matters if the jury believes that he was impaired or not.
To clarify for the record, my question was not asking for an opinion as to whether she believes he was impaired. Rather, I was asking what she is basing her decision on, whether it's based on one individual factor as compared to the totality of the circumstances. Therefore, it would not be invading the province of the jury. And in addition to bolstering, this isn't bolstering, it's just what factors she considers in her investigation, which is standard protocol within her field. Therefore, it's not bolstering whatsoever. Rather, it's just giving the jury an insight as to what exactly she's looking for in her investigation.
My response is that the state specifically asked what she looks for when looking for indicators of impairment, and she does not determine impairment. The jury determines impairment. So for that reason, I state the same objections, but you may proceed.
Officer Oliver, when you're investigating someone for DUI, are you considering only one factor, or are you considering multiple factors?
The totality of the circumstances, which is all the factors together.
Okay. So would you have considered things beyond the speeding and the lack of headlights?
Objection, speculation.
This witness, for the record, this witness would have personal knowledge as it was her own mindset. Therefore, it wouldn't be diving into anyone else's mindset. So based on the rules of evidence, that would not be speculation.
I would argue that this speculation is also not relevant to what she looks for in other situations that are not this one.
Do you mind asking that again?
Yes. And also, just one last time for the record, it's not asking about other investigations, it's asking about in this particular investigation. Okay, Officer Oliver, in your investigation in this case, after noticing the headlights off and also the speeding, did you look for other signs of impairment or indicators of impairment before calling Officer Muth to the scene?
Yes.
And what were those extra indicators that you saw or noticed?
Slurred speech and watery, glossy eyes and confusion.
And can you elaborate a little bit further on what you mean by confusion?
Confusion, like fumbling with the documents, trying to give me his identification.
Okay. Speaking of identification, I want to move on to another point that the defense talked about with you. Previously in your cross-examination, they mentioned that you did not review any notices sent to the defendant about the suspension of his license.
Correct.
Okay. So with that being said, is it your job to mail out notices to the defendant or other individuals?
No.
Is it your job to review the notices specifically?
No.
Okay. What's your job when you're investigating someone for that type of a thing?
So for that particular crime, driving without a license, it would be to either determine knowledge or no knowledge of that suspension, revocation, whatever the case may be.
Okay. And how do you go about doing that?
Using David is an example. You can see at the top of the page under the person's information, it will tell you whether or not it's been suspended, the date that it's been suspended, and then whether it's chargeable or not. I don't rely on just the chargeable or not. Like if it says chargeable, I don't always rely on that. I like to do a little bit more research into the history of driving. So I look to see if the driver states or there's proof that the address that they've provided or is provided is the same address that the notice was sent to.
Okay, so when you're looking in the system for this case to see whether the defendant had notice, were you able to determine if notice was sent?
Objection, lack of personal knowledge.
For the record purposes, this witness has just indicated in her testimony that she did review the records and that the records indicated that a notice was in fact sent. Therefore, it would be within the personal knowledge of this witness and she would be allowed to testify about it.
Response, she looked off of the Florida Department of Highway and Motor Vehicles paperwork and stated that it was sent. That is not personal knowledge, just for the record, but you may proceed.
Did you have any indication in your system that notice was sent by the Department of the DHSMV?
Yes, it says that a notification was sent.
Okay, and I'm handing the witness what's already been entered as State's Exhibit 2. Could I direct your attention to page 2 of 7? Officer, under this section, it's towards the bottom of the paper, it states sanction information. Could you read the first sentence after that header?
Objection, best evidence is the paper.
The state moves to publish this, so therefore it can be published in this manner to the jury as well.
The first sentence says, sanction information. Notices are mailed to the last address provided to our agency pursuant to Section 322.251 Florida statute.
Okay, now before that specific sentence, are there any symbols right before notices?
Yes.
What is the symbol?
It's a asterisk,
Okay.
a little star.
Now, can I direct your attention to page 4 and 5, or starting from page 4. When you look at the columns and it says notice provided date, is there an asterisk there as well?
Yes.
Okay. So what was the address on file for the defendant according to the DHSMV?
429 West Brevard Street.
To your knowledge, was there any other address in their system?
Objection, lack of personal knowledge. She doesn't know what all is in their system. She doesn't work for the DHSMV.
Okay. I'll rephrase the question. In this document, is there anything in this document that says a address other than the Brevard Street?
No.
When you checked your system in David, and while you were still in your police car at the scene of the crime, did you see anything related to an address other than West Brevard Street?
Objection, speculation. She just testified that this incident was from over a year ago. How does she know what was in her system in David over a year ago, and if she was looking for other addresses at that time?
The witness has the ability to testify whether or not she has knowledge of that. It's not speculation if it is within the purview of their knowledge, and the witness has the ability to say whether or not she does remember or not. Therefore, it is not speculation.
As a response.
Objection. I would ask then for those questions that relate specifically to her knowledge of things at that time for Exhibit 2 to be removed from her purview, as it does not accurately reflect what was in the system on May 7th, 2023.
The witness has previously testified that this information is within the same information that she had access to.
You can proceed with the question. Was noted.
No, objection. She's also testified that there's information that was after May 7th, 2023.
The only information that's been referred to or published at this point has been to the information that was available to her. We're going to note the objection for the record. We can discuss it with the court. For now, in the meantime, Officer Oliver, I'm going to ask the question again. At any point in your investigation, when you're looking into David or the records of the defendant at that time, did you see anything other than a West Brevard Street address?
Not that I remember.
Did the defendant tell you anything other than a West Brevard Street address?
Objection, speculation, and he wasn't asked.
Again, speculation for the record is diving into the mindset or thinking without about something not within the knowledge of the witness. That if this individual indicated that she would personally have knowledge of what statements the defendant made, therefore it would not be speculation whatsoever, and she can testify to what she recalls.
I would also argue, commenting on his pre-arrest silence, he wasn't ever asked this and before Miranda or afterwards, like if he changed his address.
Miranda does not apply to booking questions, so when it comes to addresses, it would not be within the scope of the right to remain silent in Miranda. Additionally, on top of that, when she did ask the defendant where he was coming from, he gave an address of West Brevard Street. He said additional things relating to his address. He attempted to produce documentation relating to the address, to which he did not and could not do. Therefore, it is within this witness's personal knowledge. It's not commenting on his right to remain silent, as it does fall within a booking question. Additionally, it's not, so that's the grounds for our thing, but it is noted for the record.
I would just say as a response, this is not a booking question. This is a question that the officer did not ask Mr. Riley on the day of the alleged incident. So I would argue that it is a comment on his pre-arrest right to remain silent, and also it would be, he was never asked the question, so I just argue that it's speculation to say that he never volunteered something that he was never asked.
He did spontaneously mention the address previously. However, I note your objection. I'm going to move on. Officer Oliver, at any point in your investigation, did you have any reason or evidence that indicated that the defendant lived anywhere other than West Brevard Street?
No.